Hi, everyone. Welcome to the third International Festival of Fintech. I'm happy to be here today, and we have a panel of four speaking on IP and tech considerations within the fintech space for M&A transactions and collaborations. My name is Violetta Kokolus. I'm an IP transactions partner in the New York office of Clifford, and we have four amazing panelists with us today. So I'll start with the introductions. Our first panelist is Jake Bishop. Jake is Associate General Counsel, IP and Marketing at Vanguard, one of the world's largest asset managers and investment advisory firms. He advises his internal clients on a wide range of intellectual property and marketing matters, with particular emphasis on trademark clearance, portfolio construction, prosecution and enforcement, and strategic transaction support. In addition to his work in the IP field, Jake has held roles at Vanguard in which he advised clients on privacy, cybersecurity, emerging technology, and compliance matters. Prior to joining Vanguard, Jake was a senior associate at Deckard's Intellectual Property Group, where we practiced together, where his practice focused on trademark law. Jake received his law degree from the University of Wisconsin. Raffi Teperdjian is our second panelist. He's corporate counsel at Protocol Labs, an open source research and development lab that builds protocols, tools, and services incorporating blockchain technology. Raffi's work includes managing investments, deals, treasury assets, and corporate structures and spinouts. Raffi also regularly researches, publishes, and presents on legal implications of emerging technologies. Of note, prior to and concurrently with Raffi's study of the law, he worked on a variety of systems development and big data analysis projects in both federal and commercial information technology consulting. In addition to his present in-house role at Protocol Labs, he teaches artificial intelligence law and policy at the George Washington University Law School, where he also received his law degree. Don McCombie is our third panelist. He's a partner in the London office of Clifford. He has over 15 years of experience advising clients on transactions and disputes relating to technology and IP. On transactional work, Don's dual experience as a litigator and transactional lawyer helps him understand key commercial drivers and what matters to judges, and crucially, what doesn't. In disputes, Don has advised on numerous cases in English courts, often in parallel with proceedings in the US and the EU. Don is a graduate of the University of Edinburgh and has an advanced diploma in IP from the University of Oxford. Lastly, our fourth panelist is Brian Harley. Brian is counsel in the Hong Kong office of Clifford Chance. He's the tech M&A leader for the APAC region. Brian regularly advises on acquisitions, investments, and joint ventures in a variety of sectors, including fintech. Brian has a global perspective on tech law, being admitted as a solicitor in Ireland, England and Wales, New York, and Hong Kong. Brian received his law degree from the London School of Economics, his MA from the University of Sussex, and an LLM from the Columbia University of Law, where he was a James Kent Scholar. So with those introductions, I think we can get started right on our panel. And Brian, if you don't mind, perhaps I can start with you. And if you could just give us sort of, a view on sort of the overall trends you're seeing in the fintech space, in particular with respect to M&A and collaborations.
Sure thing. Thanks very much for the invitation to be on this panel today. So 2023 was not a great year for M&A overall, but it wasn't too bad for fintech M&A, a little bit of a dip in the overall numbers, but not too bad considering the overall climate. Where there certainly was a greater difficulty for fintechs, and it was on raising funds side, which means that we now have a market where we're hoping to see some green shoots, but we have quite a lot of startups in the fintech space and other technology areas who are probably running a little bit low on funds, feeling that they may need to look for exits just at a time when we're hearing from private equity houses that they have tremendous amounts of dry powder, and strategic investors may be feeling a bit more appetite for acquisitions as interest rates ease a little. So that's the overall context, but actually the dynamics play out very differently in different subsectors of fintech. And I might mention a few key ones, the first being crypto. Crypto has obviously had a bumpy few years with the implosion of FTX and other crypto debacles. And that saw a big dip in fundraisers with, any startups in the crypto space finding it very difficult to raise new financing. But the recent enthusiasm for Bitcoin ETF has put some spring back in the step of Bitcoin and the crypto ecosystem as a whole. And I'm expecting that to drive deals in the year to come. That's also in the background of a very interesting longer-term development with the emergence of much more mature regulatory frameworks around crypto in a number of jurisdictions around the world. And I'm sure some of the other panels as part of our Festival of Fintech will be discussing those issues. But I'm looking forward to seeing what may prove to be a bit of a new world of crypto after the crypto winter, one that is more regulated, one that has maybe a different set of leading players from the earlier age of crypto. Another area to mention is buy now, pay later, an area that saw a huge amount of growth and investment over the past few years, but is now probably a fairly saturated market. And that means you've had a number of players in this space who have been burning cash, attracting new users by incentivizing them through discounts, who are now struggling a little bit and may be heading towards forced exits, a kind of dynamic that is likely to lead to deals and consolidation in that space. Last but not least, I will mention AI, clearly the big tech story of the last year and a half or so. We've all been gobsmacked at the amazing leaps of technology of this latest generation of technologies, the generative AI and LLMs. Now, similar to other areas outside the kind of privileged core of tech leaders in the AI space, like OpenAI, like Facebook, like Google, Microsoft, and so on. The rest of us are still struggling with the challenge of finding ways of effectively deploying this latest generation of AI. And I think it is fair to say that we have not yet seen the generative AI fintech unicorn. But that is still a space that I'd be watching very closely. If you look at the leading fintechs who have AI baked at the core of their products and services, most of those are of a slightly older vintage who have been deploying earlier generations of AI technology in the fintech context. I think there's certainly a lot of attention being paid to the potential of AI, same as in the broader technology sector. And I'm sure we will see strong valuations for those fintechs who manage to capture the value of the latest generation of AI technologies. There'll be plenty more to say on the broader fintech space, but I'll leave my comments at that for the moment. But just to say, looking forward into 2024, I'm expecting a fairly lively market for fintech M&A.
Great. Thanks so much, Brian. So given that, and I'm hoping we're going to be having an exciting market for 2024. Don, if I can turn it to you and just ask you a little bit to discuss sort of IP and tech considerations in the diligence of fintechs, and if there's any sort of key differences in comparison with other industries.
Sure. So, yeah, thanks, Violetta. So I've worked on a lot of fintech deals over the past 5 years, so both as outright acquisitions and investments and funding rounds. And in most cases, it's my team that will do the due diligence, the IP due diligence on those deals. I'm going to spend a few minutes summarizing the things that I look for on due diligence, and I'm also going to cover the common mistakes that I often see, which can actually, they can easily be avoided, and most of them cost very little to avoid in the first place. So the first point to note is that IP doesn't just mean patents and registered trademarks. Often when I first see a data room on a deal, the only items that will be in the IP folder are lists of patents and trademarks. And it's actually very common for fintechs not to recognize that their software is by far their most valuable IP. And for a lot of fintechs, that's really the core asset. But you should treat it as IP. And so software is protected by copyright, which arises automatically on creation, without the need to register the right in most countries. So you can register copyright in the US, but rights and copyright still arise automatically. In the UK, it isn't even possible to register copyright. And so as copyright is generally an unregistered right, we always need information for the target company itself. And so there's no public registers for us to consult for doing due diligence. And what matters most is the ownership of software IP, which in turn depends on who actually wrote the software code and the status of the individual coder at the time they wrote the software. And we look at these issues on due diligence and M&A, but it's easiest and cheapest to make sure that ownership is dealt with at the time the software is created by including necessary terms and contracts. And in terms of like bang for buck and looking at how to manage like your IP within a company, within a fintech, those are the things that are cheapest and easiest really to focus on. So how it works generally is if software is created by employees of the target fintech company in the course of their employment, in most countries and subject to specific terms of employment contracts, the target company, so the fintech that we're looking at investing in or acquiring, the target company will own the IP in that case. However, if software is created by independent contractors, either individual contractors, which are very common in any kind of field of software development, or development companies or agencies, the first copyright owner will be the contractor themselves, unless there's a written assignment of copyright. Even if you've paid someone specifically to write software for you, the mere fact of you paying for it doesn't give you ownership. You need an assignment document. And that's probably the single biggest IP issue that I see very regularly on fintech deals. So it's just gaps in the contractual coverage. And you can sort these things out. If you're managing your IP properly in-house, you can sort that out pretty cheaply. The second big issue in software that we commonly see is on license rights. So very commonly, companies will commission a developer to build something new on top of that developer's existing platform. And the developer will normally happily give you ownership of the code that they create specifically for you, but they'll often only be prepared to grant a non-exclusive license to their pre-existing platform. So IP in the existing platform, that's often known as the background IP. And ensuring that the fintech gets long-term, secure rights to use the background IP and is able to sub-license those rights to its own customers, so license those rights onto its customers. That's really important, and particularly for any software that's integral to a fintech's core software platform that isn't just a standard commercial piece of software that you can buy from one of the big tech vendors. Sticking with software licensing for a moment, the third big point to note is on the management of open source software. Now, Raffi is going to cover open source in more detail during this talk, so I'll be very quick here. Now, everybody uses open source software now. It would be a big concern if a fintech was not using open source. And in fact, if a target company now tells me that they don't use open software, I'm skeptical to begin with. I really don't believe them. Instead, I assume that the deal team just hasn't spoken to the necessary people. So I'll ask further questions around that. What you look at on due diligence is not whether open source has been used, but really how open source has been managed. So that involves looking at the target's open source policy, their inventory of open source components, the basis on which the target service is delivered. So, for example, whether delivered solely as a cloud service, which is lower risk than distributing copies of software to customers. And then you look at the specific open source licenses that have been used. In some cases, you can also have code scans run on a target company's products, but those are like you don't come across those all that regularly on most M&A. But Raffi will come back to open source later, looking at the different types of licenses. So that's all I'll say about open source for now. The final point I'm going to cover is on patents. So just in case that's not clear from my accent, so it's patents, we tend to pronounce them patents, doesn't matter a great deal, but the value of patents, what does matter is that the value of patents for fintech businesses varies between regions. So in Europe, the scope for obtaining patents for software, algorithms and methods for doing business, that's quite limited. It's a mistake to think that you cannot get patents for software or for fintech inventions at all in Europe, but the limited scope of protection that these give you and the cost of acquiring and enforcing patents might be disproportionate to the benefits. In the US, software patents tend to be more valuable, but they're still fairly expensive to acquire and really very expensive to enforce in most cases. The one point to remember regarding patent protection really is this. If you think you might want to seek patent protection, speak to a patent attorney before you publish anything. And by publishing, I mean making any kind of public disclosure about the invention. That might be a blog post, a statement on a website, or in a technology white paper that you get in certain fields. Even just telling someone without putting an NDA in place first can endanger the future patent protection. And unlike copyright, you don't get any patent rights automatically. You need to proactively apply for patent protection. That application process costs money, but there are various ways of managing patent budgets when money is tight, so which potentially allow you to postpone costs to align with future funding rounds, for example. And brands are also important, but I'm going to hand over to Jake to cover these in a bit more detail.
Great, thanks, Don. Yeah, so Jake, if we can turn to you and get your insight on branding, especially given all your experience practicing trademark law. I think one thing that often comes up, especially for early stage companies, is that a lot of these early stage companies do not have registered trademarks. So any tips or pointers you have on how do we start, diligencing that, and where do we go from there? And any other insights you may have to share on branding would be great.
Yeah, sure. So I think it's not just once in a while that a target company doesn't have trademark registration in the United States or somewhere else. I would say more often than not, they do not. And I think they're probably just focused on a lot of different things. It might be because of just different thoughts of how important it is to the overall business. But if you look at some of the biggest startups or tech companies, fintech companies you can think of, I'm talking FTX, Robinhood, Stripe, Coinbase, Chime, Facebook, Snap, pretty much everybody that's huge. You will find that they went live with their business, or they formed, or they started doing something before they even filed a trademark application for their name, much less actually obtained a federal trademark registration. So you're in good company. I don't think it's a red flag if a target does not have a trademark registration on file, or even an application on file. And in fact, I think a lot of times the prospect of being acquired, or prospect of an investor wanting to put money into it, is what prompts the trademark filing. So all that aside, to say it's not necessarily a red flag. And it also doesn't mean that the target doesn't have enforceable trademark rights, because at least in the United States, you acquire trademark rights through use of a mark for a particular product or service. It's not just having the four corners of a trademark registration certificate. But whenever you see that there is no trademark filing, there are some potential issues that could be lurking, and I'm going to talk a little bit about those. So the biggest one, which I've seen more times than you can imagine, is that the company actually did try to file for trademark protection of their mark, and either got refused or inadvertently abandoned their application. So, you need to take a deeper look at what they disclose in the data room whenever they say that they have had trademark filings. You really need to take a look closely at any applications they might have had, or any claim that they say that they don't have a registration, because it could be that they actually filed and their mark is not something they can claim exclusivity in. So that's one issue. But if you assume that there was no application ever filed, basically two main issues I think there are. The first one is that the name may not be protectable as a trademark at all, regardless of whether some third party has rights. And there are a whole host of reasons why this might be, the term might, especially in fintech, when there seems to be some conflation sometimes between the technology and the name of the technology. Sometimes the name that people are functioning under is actually a descriptive term or a generic term, which is not entitled to trademark protection absent some showing of acquired distinctiveness, which is, for a startup, really difficult to show that the public views this as an exclusive indicator of source. I'm thinking something like maybe OpenAI or ChatGPT might hit that threshold, but most marks are not going to hit that threshold. So if it's a descriptive term, it can't be protected as a trademark, which means third parties are free to use it. Your target company is also free to use it, but they can't stop others from doing it. So you want to take a close look at that. But there's other ways that marks can be ineligible for registration, and those include it could be a surname. So if you're acquiring something that a target that is named after the founder or something like that, that name probably is, you're gonna have a difficult time getting a registration for it. If it's geographic in nature, you could have a difficult time in the US. If it's scandalous or offensive, those things usually can't be registered with the trademark office, or some combination of those things. So that's kind of one bucket. It's just not protectable as a trademark to begin with. The other issue, which is also pretty common, is there's a third-party company out there that already has rights in that name for the same services, for similar goods or services. Maybe they have, I don't know how familiar everybody is on this call with trademark classes, but maybe they have a trademark registration that's in the same international class, and it's got a broad identification of products and services, and the trademark office would use that to block registration of a third party, of your target company's application if it were to be filed. So that's another issue. And incidentally, I did mention OpenAI a little earlier, and I just have to say, I don't know if anybody, hopefully nobody's on the call from OpenAI, but they ran into a whole bunch of issues with these issues, with both OpenAI and ChatGPT. And one of the more interesting ones, I think, is that they did a press release about talking about, the consortium and the purpose of OpenAI, and, Elon Musk was involved, and all sorts of folks who are very notorious or very high profile were involved. And there was a press release. That same day, a cyber squatter came in, registered open.ai as a domain name. They filed a trademark application for OpenAI. And I think they're still trying to unwind that whole situation. So it's just an aside that things can come up, especially if it's sort of a higher profile startup or a higher profile target. So it's just something to keep in mind. These public statements that mention names, they can end up causing problems if there's a press release or something talking about it. So that the higher, the more desirable the target, sometimes it can cause trademark issues. So with all of that instead, how do you handle this situation? I think obviously what's in the data room, you have to take a close look at. You have to take a close look at any office actions that have been filed against a trademark application if they've disclosed it. Take a look at the whole registration process if they do happen to have a trademark registration for their name or product. I think that's one thing to keep in mind as well, is you've got the company name, but then you also have any products. So you can't just look at the target's name. Usually they should be disclosing all names that they use for their software, for their platforms, anything like that. But you want to push on that to make sure that you're getting disclosure of all the different names that the company might be using, not just their company name or their primary brand. And then ideally you would do a trademark search on all of these things. So most commercial searches, they cover the federal registers, they cover each country register, but then they also cover state registrations. They do common law registrations, common law usage, not registrations. They'll do company name databases, so secretaries of state, they'll search, domain name searches, app store searches. So it's all covered by these commercial search reports that you can acquire. And two companies that you can use are Thomson CompuMark. So Sagis is their platform, which is a really good one. Core Search is another one. And actually, Sagis has this sort of semi-automated version of it called TM Go 365, where it's sort of a cheaper version. You just put in the name that you want to search, and it spits out all the relevant hits that might be of interest to you. Obviously, there's sort of some downfall to that because it's great that you have the data, but you actually have to do something with that data. So I think you really do need a trademark expert to take a look at that stuff, just to contextualize it, to sort of make sense of everything, to see if there's room for coexistence with some of the hits that might turn up, because there's a lot of noise that shows up in some of these reports. And you just want to have somebody who can parse through that and give you a sound recommendation of sort of the trademark strength of a particular target's portfolio. And I've talked a lot about the U.S. perspective on this. I would assume, Don, that in the UK and the EU, it's pretty similar, but
yeah, the things that you've mentioned are all exactly the things that we would look at in the UK and the EU. The systems are very similar, so there's a relatively high degree of harmonization. The same thing in the UK, you can get unregistered trademark rights that are protected by something called passing off. Across the EU, there is quite a diversity of legal approaches there, and registered trademarks are relatively cheap to obtain, or at least to apply for. It's only when there are kind of objections from third parties that the costs tend to stack up. But they are more reliable than unregistered rights. I mean, something that we do see with fintechs and growth companies in particular is that they might be active in a certain region, and the plan going forward is to expand into new regions. So if they're active in the UK and EU, the fact that they've been operating for years under a certain brand, that often does give some degree of comfort that no one's popped out of the woodwork and asserted any rights. But as they get more successful, and as you mentioned, Jake, as you become higher profile, that might make you more of a target. But if you expand into new markets, that can often be like when you encounter trademark issues. So if a European fintech expands into the US, that might be when the US issues start to arise. But yeah, in general, the approaches that you would take in Europe and the UK are exactly as you've outlined, Jake.
Yeah, I would just add too quickly, we talk about the fact that you don't necessarily need a trademark registration in either the UK or the US to conduct business, to have trademark rights, to prevent third parties from infringing on your mark. But, it is just so much better practice to actually have the trademark registration, which is why you see when there's interest in these target companies that the applications soon follow. Obviously, it creates a rebuttable legal presumption in the US that you have exclusive rights there. It's just a lot easier from a process perspective to enforce your rights when you have the certificate to show your rights. But one thing also, two things I should say. One is just a really great deterrent to keep people from using your mark in the future. So everybody's ordering these commercial searches. So when they get those commercial searches and they see a formal registration, it's different qualitatively than whenever they see a common law usage. Like they know that you are invested in that mark, that you'll probably fight to enforce that mark. So it's just a really great deterrent to get, especially if you're on the weaker end of trademarks. Like if you're on a borderline descriptive trademark and you can get a registration for it, you really should do it. The other thing I would say is we're talking a lot about kind of common law countries, but there are a lot of countries out there that really require a trademark registration for you to have enforceable rights, especially places like Brazil or sort of Latin American countries. Asian countries tend to be that way as well. And one of the benefits of getting a US registration, if you're a US company, is that you can then use that to file what's called a Madrid registration and get protection in some of these participating international jurisdictions. So that's a really great benefit as well.
Great. This is all very interesting. So speaking on other types of IP and intangible assets, I think we can turn to sort of software and computer code. I know, Don, you were talking about it a little bit earlier during our panel. So Raffi, if I can direct this at you. So I would say most, if not all, sort of important technologies in fintech rely heavily on computer power and, of course, software. And there's an extensive use of open source code in the industry. So can you outline some of the basics on this, and perhaps if you're able to sort of share the position that Protocol Labs takes on it?
Yeah, sure. Thanks, Violetta, and thanks so much for inviting me to participate here. So I think it'll be helpful to talk just a little bit about blockchains in general, and then why open source licensing is important to them, and talk about a little bit about the different types of open source and go through some examples. And then I'll turn to Protocol Labs and our position on this. So when you talk about blockchains, there's a lot of different definitions out there, but a good one to think of is it's a system of records that stores multiple exact copies of data across several or more computers in a network. It's essentially a shared immutable ledger. And it's really not an entirely new technology, but instead an amalgam of several different technologies that, when combined together, form something new. But four of the primary technologies used in blockchains are asymmetric key encryption, hashing, Merkle trees, and peer-to-peer networking. And so using this technology together, you can create a secure records of transactions using cryptography to validate authenticity of the transactions without the need for a third-party intermediary. And this has lots of different use cases, right? So some of the ones that you may know of, is just simply for exchanging ownership of a fungible digital asset. You can think of Bitcoin as an example of this, or exchanging ownership of unique digital or physical assets. You can think of NFTs as an example of this. You can also think of smart contracts, which are really just pieces of code stored on a blockchain. They'll self-execute once they're deployed. Or you can create entire virtual organizations known as decentralized organizations, autonomous organizations, or also known as DAOs. And there's lots of other innovations in this space, but that's just a brief overview of blockchain. So why is it that open source licensing is important in this industry? And as you mentioned, most distributed packages of popular blockchains are open source. And there's several reasons for this. But, some of them are, that there's a decentralized ethos in blockchain and Web3 communities, which requires that software is easily accessible by many different groups working on the code. They're not always part of the same organization. There's also a belief in the community that the internet should be open and free, and that knowledge should be shared easily and without boundaries. And that's just something that's baked into this community at its core. And it's important because, practically speaking, if a critical piece of software in a blockchain has a license that's incompatible with the default license for your stack, then that can break the entire protocol or prevent it from functioning properly. So all that to say, there's a lot of different interdependencies on different blockchain software stacks that need to be able to be used together in a very permissive way. So now I'll turn to what are open source licenses, and just a brief overview, right? But these are software licenses that allow content to be easily used, modified, and shared. And there's two main types. There's permissive licenses and copyleft licenses. And just going over them briefly, a permissive license, carries usually only minimal restrictions on how the software can be used, modified, and redistributed. And software licenses using this type of license tend to be more compatible with other licenses. Copyleft licenses tend to be trickier to comply with, and it's not always clear what the boundaries are. There's more restrictions on derivative works than with permissive licenses when you're using copyleft licenses. So basically all that to say, whereas in the permissive world, creators are mainly concerned with maintaining openness with the original work. In the copyleft world, it's kind of a more hardcore open source ethos, basically saying if you use this work, derivative works will also have to follow these very open source rules. And in the blockchain community, a lot of developers of popular chains, including Protocol Labs, use permissive licenses more so than copyleft. So with that, let's look a little bit at the different open source licenses that are commonly used and examples of blockchains that use them. So an example of a permissive license, the first one ever created is the BSD license, which is created by Berkeley. It's called the Berkeley Software Distribution License. This license is super permissive. It allows almost unrestricted freedom to use, modify, and distribute software. And it comes in several different variants, which mainly are different in their requirements regarding the use of the name of the project or its contributor. And for an example in the blockchain community, while not a blockchain itself, FreeBSD is an operating system that blockchain software may run on and uses this license. Another example of a permissive license that's very, very popular is the MIT license. And it's one of the most permissive and widely used licenses in the entire open source community. The text of the license itself is very short. If you Google it, it's literally less than a page. It allows users to do almost anything they want with the code. That includes copying, modifying, merging, publishing, distributing, sublicensing, and selling the software. all provided that the original copyright notice and licensed texts are included with any substantial portion of the software. And examples of a couple of projects that use this, you may know very well, are Bitcoin and Litecoin. Another example of a very popular permissive license is the Apache license 2, Apache 2 license. The text of this is longer than the MIT license, but it's also extremely permissive and allows users to freely use, modify, and distribute the software. It also provides an express grant of patent rights from contributors to users. And it requires preservation of the copyright notice and disclaimer, but it does not require that derivative works be distributed under the same license. One additional requirement that this license has when compared to the MIT license is attribution, meaning that the user of the license needs to provide an acknowledgement giving credit to the copyright holder or author of the original work. And also, you need to provide notice if you've modified any of the files. And an example of a project that uses this is Hyperledger Fabric. Hyperledger was created by the IBM Linux Foundation, and IBM was originally going to use Ethereum for its projects, but ultimately switched to creating the Hyperledger blockchain and applying the Apache license because they were concerned that Ethereum's use of a copyleft license, which I'll talk about in a sec, known as GPL, would be incompatible with instances where people would want to create proprietary derivative works on top of Hyperledger. So lastly, I'll talk about GPL before turning to Protocol Labs. So GPL stands for General Public License, and it's a copyleft license that requires any modified versions of a project to be open source under the same license. So it ensures that the freedom to use, modify, and distribute the software are not just in projects that use that software, but are preserved in derivative works as well. And there's several different variations of it out to be used. And Ethereum is an example of a blockchain that uses this project. So now I'll turn to talking about Protocol Labs. So in Protocol Labs, we use a MIT Apache 2 dual license as a strong default governing copyrights and patents for our software projects. So this approach means that all contributions are available under the most permissive commonly used licenses, and dependent projects can pick the license that best suits them. It also means that contributors explicitly license any required patents alongside each contribution, which minimizes the risk of infringement claims against our organization and our users. This license structure is our default, but if we want to apply a different license to a new project or future contribution to an existing project, we leave open the possibility of soliciting feedback from the project team and the company's employees, and ultimately making a decision on whether to use that alternative license if it aligns with our mission. And we prefer using this MIT Apache 2 dual license combination because it doesn't just have to be Protocol Labs working on a stack of software. The intention with creating decentralized technologies is that you have many different companies and builders that are easily able to work together. We have many different contributors who work on many different projects. We want to make sure that anything to develop here is not blocked from being worked on by others. To make the reasoning for this clear, imagine if the creators of one of the foundational blockchains, like say Bitcoin or Ethereum, decided to use a more restrictive copyright regime to develop software or even obtained a patent on some of the tech. It would be much more difficult for others to freely collaborate, and you wouldn't end up with such a flourishing broad ecosystem of different projects building all this cool stuff. So I know that was a lot to cover, but hopefully that provides a good overview of open source software and its importance to blockchains.
Thanks, Raffi. That was very, very helpful. So speaking of doing cool stuff with blockchain technologies, Jake, if you don't mind, can I ask you about sort of use cases in the asset management space and outside of sort of the most famous application of to crypto?
Yeah. So I mean, obviously, with the SEC approving spot Bitcoin spot ETFs, it's been kind of crazy in the asset management space. Vanguard has been pretty vocal about our position on crypto generally and how we're kind of not getting in that space at this time. But we're still doing plenty in the blockchain space. Thinking a lot through tokenization of funds. I think that's sort of like the hot topic at the moment, is just this idea that you can create tokens that stand in for shares of a particular fund and completely digitize that. I think we're talking about it in kind of more traditional senses of tokenizing stock shares and other securities, but I think it's particularly interesting for private equity products and other things that are a little more illiquid. because then it gives people an opportunity to invest in something that they wouldn't otherwise be able to. So I think that that's a really fascinating use case, something that's pretty consistent with Vanguard's overall mission, and something that we've looked into a decent amount. I think there's a lot of private blockchain, because we talk a lot about public blockchain, it's like Bitcoin or Ethereum, but when you think about your own private networks that you can create, there's a lot of sort of back office and business process stuff that you can do that's really fascinating in the asset management space. I think it can really aid in settlement. It can aid in sharing things like index data and making sure you have an immutable way to transmit immutable data. It's really helpful to make sure we're all working off of the latest and greatest data, and that's using blockchain to do that is a really great way to do it. And we've had lots of pilots with different companies in the industry, with various blockchain companies to do that. So yeah, I think there's a lot of things that are not the C word that that people are getting involved in.
Yeah. No, and I'm glad you also mentioned sort of back office functions. I think we'll of course touch upon AI in a bit in our panel, but I feel like there's a lot of back office uses that help create a lot of efficiencies within the systems, information sharing, and the fact that it's immutable. I also even know there's lots of use cases that people mention for IP management, right, and tracking sort of the ownership and transfer of IP assets. So maybe Raffi, if we can go back to you, because what you were sharing about Protocol Labs was really interesting and a unique perspective. Are you able to share and explain sort of the patent non-assertion pledge that I think Protocol Labs has been very vocal about?
Yeah, sure thing. So if you couldn't tell from that broad overview before, the general ethos of the company and the Web3 blockchain community is that everything's very open source, and that they're, above all, we want an open and free internet with free sharing of data, right? So that also ties into this patent non-aggression pledge that Protocol Labs has made. So we do have a few patents related to decentralized networks, protocols for decentralized networks, but as I said, we have this patent non-aggression pledge. And the pledge basically is saying that if we receive patents related to our software, we pledge not to be the aggressor in a patent suit. So that means that we won't enforce any patents of software inventions Protocol Labs owns now or in the future, except against a party who files, threatens, or voluntarily participates in a claim for patent infringement against Protocol Labs or any third parties based on the party's use or distribution of technology created by Protocol Labs. So all that to say really is we're never going to play offense and act as a patent troll to stop people from using technology that we helped develop. We're only going to play defense if someone tries to sue us. And this really makes sense for us, again, as I said before, because we have this flourishing community of devs, both within and outside of Protocol Labs, and they all, generally feel quite strongly about making sure that nothing they develop will be used to block others from building on the tech.
Okay, great. Thanks for that, Raffi. Don, can you talk a little bit? I said we touch upon AI. Hopefully it hasn't taken all the oxygen out of the room, because I know people are so tired of hearing about AI. And this is a bit of a broad question, but what would you say are sort of the key IP and tech concerns when evaluating sort of these new and unique use cases for AI?
Sure. So, as you might expect, interest in AI has exploded over the past 18 months. And banks and fintechs have long been like early adopters of AI. I think with the real big development in the last 2 years has been generative AI, which does raise a lot of new IP issues. And so there's already a lot of litigation underway regarding AI training processes. So that's training the big foundation models. So for example, the OpenAI's GPT models. Most fintechs won't be training their own foundation models, but they still need to be careful when fine-tuning models. So you have the general purpose foundation models, and then they'll be fine-tuned for specific uses and specific use cases. Checking the status of the data sources that are used for that fine-tuning process, that's generally pretty important to make sure that you're actually allowed to use that data, whether it's because of general copyright issues, and that what you're able to do varies quite a lot depending on the jurisdiction that you're doing the training in. But also there might be contractual terms if you're getting data from like some of the big business information or financial data companies. So you need to check that. There's also the potential for IP infringement liability relating to the outputs of AI tools. And that, again, the level of risk depends on the specific use cases. So coding tools, chatbots, image generation, and text generation tools, they all raise slightly different risks, and your level of risk will depend on exactly how you're using those tools. And some of those risks can be mitigated through like some of the tools have got filters, and those can be applied at the prompt stage, so it just won't accept prompts which are most likely to violate like policies or third-party IP. You also get filters on outputs as well that prevent like outputs which are too close or too similar to training inputs, and that's a way of safeguarding against infringement. And as another fallback, many of the big providers, the commercial providers of tools, they often provide IP infringement indemnities. Now, they didn't to begin with, but the way that the market has moved is a lot of the big providers still, they now provide indemnities against infringement. But you've got to look at, well, what does that cover? What does it not cover? And are you using the tool in a way that will actually benefit from those types of indemnities?
Great. So being mindful of time, I know all of us could talk about these topics for days, but Brian, I know you started off our panel talking about overall trends, and perhaps you can also talk about sort of overall trends again about AI. And I mean, is every investor now looking into companies and seeing, are they all in on AI? And if they're not, is there any interest? I mean, what do you see going on in the market right now?
Well, I could say over a career of doing M&A with a focus on tech, I've seen the kind of due diligence questionnaires and the warranty schedules grow over time. They've always had a pretty padded section on IP, and they had a kind of smallish section on computer systems. And that's grown over time with more and more around data protection, especially with the advent of GDPR. And most recently, we're seeing a mushrooming of questions around AI, how it's used, and then the warranties to match those questions. We obviously, as a firm, very active in this space, have been developing standard due diligence questions around this and warranties to match. And that is, responding to an obvious trend in the market, a huge amount of curiosity around AI systems, but also a great consciousness of the risks involved. I think we've all been following the development of the EU AI Act, the most ambitious attempt at a kind of comprehensive AI-specific regulation, and one that will have a lot of implications for the developers and users of AI systems. But as Don was mentioning earlier on, to many in the fintech ecosystem, AI is not a new thing. Generative AI has generated a huge buzz over the last 18 months, but actually, robo-advisors, the use of automated decision-making and so on, that's been in the DNA of many fintech companies for many years. And because of the nature of fintech, a sector that is always quite close to regulated activities, there's been a great consciousness around the risks of AI. So I think that kind of natural focus that is kind of mushrooming at the moment across the piece in terms of general tech investments, and indeed investments outside of the tech sector per se, is particularly solid and very much becoming the norm in fintech, at least for any of the fintechs that have a meaningful reliance on AI technologies.
Thanks, Brian. So I think we probably have time for a question. So this relates to sort of AI code generation. So the question is, creating any kind of a distributed ledger technology relies heavily on investments in programming and infrastructure. Can you share insights on the risks and benefits of AI code generation? So Don, I know you have clients who are considering this, so
Sure.
or actually who have already implemented this. So do you want to share some insight on that?
Yeah, so I mentioned earlier that like the different types of use cases like raise different types of risks, and one of those like classes of risks is, well, are you using like coding tools which as part of like the AI system they automatically generate code? So often it will be you'll start typing, or you'll, in some of them you can put in your comments about what a particular kind of routine or function is going to do, and it will write it automatically for you, which has the potential to greatly increase the efficiency of coding. One of the issues has been, though, is that, well, does that raise new IP issues? And there was litigation in the US almost as soon as these commercial AI coding assistants hit the market in 2022. The products have actually moved on a lot since then, but the big concern from a user's perspective regarding IP is whether the AI tools regurgitate existing code for which copyright might belong to third parties. So this could be open source code that's subject to one of the nastier licenses, so one of the copyleft licenses that Raffi mentioned, or it could be completely unlicensed. And in either case, if that goes into your code, which is then released or goes into production, that could raise infringement issues. But many of the tools now use filters, so I mentioned those already, and in the coding tool context, those can prevent the copying of known third-party code, and they can also flag known open source code, so that the user then has the choice either to choose to comply with the applicable open source license terms, or to remove that code from their software. So these tools are developing all the time. But if people in your organization, or if you see that the target company has used these, we might want to ask a few further questions just to make sure we understand how they're used, and if they've got kind of additional kind of quality control processes in place regarding the use of those tools.
Great, thanks so much. So that wraps up our session today on IP and tech considerations for M&A and collaborations within the fintech space. I'd like to thank all of our panelists for taking the time to join us today. Found this very useful and informative, and I hope everyone else did. For those of you who are continuing on with the program, if you could just stay online, there will be a link that pops up on the screen when the session ends, and it'll direct you to the next panel. Thanks so much. Take care.
Thank you very much.